Hello and welcome to the Canadian Privacy Lawyer YouTube channel. Today I'm going to talk about social media background checks and what are the privacy and human rights legal considerations involved in doing those. When I speak at conferences and talk to HR professionals, the number one question that I get relates to whether or not in the hiring process, HR managers, hiring managers, and others are lawfully able to do a background check by putting the person's name into their favorite search engine or looking for social media accounts that that individual candidate might have. And it's a tricky spot, and so I'm happy to provide some further information and background, not specific legal advice, hence the disclaimer. So what I'm going to talk about are what are social media background checks, what are the privacy issues associated with social media background checks, in particular privacy compliance issues, human rights issues in social media background checks, and I'm also then going to talk about best practices and risk management. So why do social media background checks? Why would an employer have an interest in finding out what an individual candidate has done in the past and has posted online? Well, I think part of the reality is that nobody uses phone books anymore. Nobody uses directories to try to track down somebody's contact information. The number one tool that's used, that most people use, when looking for contact information for a company, contact information for an individual, or looking for more information about a company's services, they just go to their favorite search engine and they put in the company name, they put in the name of the individual, and so whatever comes up in that search result is going to be something that's going to come to the attention of customers or stakeholders or others. It's equally important or equally applicable in public service. The reality is that all those people will be searching for that information using their search engines, and employers, I think, reasonably should know what is going to come up when somebody else looks for that employee's name. There's also the reality that things that people have done online, things that they posted, particularly recently, can provide you with information about that individual's judgment. Was it a good idea for them to post this? Did they post something that was unduly critical of their former employer or unduly critical of a competitor? Or did they engage in any other form of mischief that would reflect poorly on the employer? One thing that people sometimes don't understand is that employers have an interest in the off-duty conduct of their employees if the off-duty conduct could be prejudicial to the employer's legitimate interests. So it doesn't necessarily matter whether or not the social media use takes place on the company's time and on the company's dime, or even that company IT equipment or infrastructure was used to do it. If it implicates the employer's legitimate interests, then it implicates the employer. And the employer has an interest in understanding what's going on and can take action. Now, this is about the hiring process. Certainly whether or not individuals can be disciplined or fired for social media activity would be a whole other presentation of its own, crossing significantly over into employment law from privacy and human rights. So what are the legal privacy issues associated with social media background checks? The reality is that it's a collection and a use of personal information. Where Canadian privacy laws are involved, the threshold question is whether it is personal information. Is it information about an identifiable individual? That threshold question doesn't care whether that information is public or not. Doesn't care whether that individual has put that information out there themselves, whether it's notorious. The question is whether it's personal information. So if you're subject to PIPEDA, PIPEDA applies to the collection, use, and disclosure of personal information in connection with the operation of a federal work undertaking or business when it comes to employment or workplace related information. Under the Freedom of Information and Protection of Privacy Act, it's about the collection, use, and disclosure of personal information. Doesn't matter whether the information, as I said, is public or notorious or otherwise. And so that, as a collection of personal information and a use of personal information, is going to be subject to that regulatory scheme. And so what you can do legally, and also how you should do it, is going to depend upon whether or not the workplace is subject to privacy laws in particular. So all public sector employers, and that's the federal government, the provincial governments, their crown corporations, their departments, their agencies, are all subject to public sector privacy laws. And their employment and hiring practices are regulated by those laws, among others. PIPEDA, our Personal Information Protection and Electronic Documents Act, the federal statute that came fully into force on January 1, 2004, only applies to the workplaces of federal works undertakings or businesses, and also all operations in the territories. And so a federal work undertaking or business is, for example, a Canadian chartered bank, a telecommunications company, an airline, a railway, those sorts of operations. So one way of thinking about it is if the workplace is subject to the Canada Labour Code, then it is a federal work undertaking or business and is also subject to PIPEDA. Now, if the workplace or the employer, or frankly the candidate, is in British Columbia, Alberta, or Quebec, their information is going to be subject to the provincial private sector privacy laws of those provinces. And so what you see left out is a significant gap. So for example, there is no law affecting the workplaces of provincially regulated employers in the provinces of Manitoba, Saskatchewan, Ontario, New Brunswick, Nova Scotia, Prince Edward Island, and Newfoundland and Labrador. So a significant gap where they are not subject to regulation in the same way in those provinces. So if you are subject to PIPEDA, what should you be thinking about when it comes to these sorts of things? Well, in PIPEDA, there's whether or not information is personal information is kind of a gateway sort of principle. But there's also Section 5 sub 3 that says an organization can only collect information for reasonable purposes, and I'm paraphrasing. And so is it reasonable and appropriate in the circumstances to collect information about an individual from social media or from other sources? And the first line of determining what is reasonable is going to be the privacy commissioner, but the ultimate determinant is a judge, although cases seldom end up in front of judges. Or can you fit within, so if it's reasonable, there are two avenues that could be proceeded with. So one is you can get somebody's consent for their collection, use, or disclosure of their personal information. Or PIPEDA actually has an exception to the consent principle for the collection, use, and disclosure of personal information that's reasonably necessary to establish an employment relationship, and the individual has been notified of the purposes. So there's still an obligation to notify, but you don't have to get consent. So it's the notification part of the notification consent. If you're going to get consent, which is the only other basis for collecting personal information in this context, you do have to provide notice of the purposes for which personal information is being collected, and then you have to get consent. That consent could be express consent or it could be implied consent. I would probably want it to be documented, written consent on an opt-in basis, so you have a record of exactly what was consented to and what those purposes were. Now, if you're subject to a public sector laws aren't really consent-based. Public sector laws allow government institutions to collect, use, or disclose personal information for purposes that are permitted by statute, that, for example, are specifically authorized by a statute, or for purposes that are reasonably necessary associated with the operations of the public body, and hiring is part of the operations of a public body, but it has to be necessary. And so I haven't seen a circumstance where social media screening has been authorized by a statute. So then you have to deal with the second option, which is that it has to relate directly to and is necessary for the activity of the public body. And so I refer to the Freedom of Information Protection Privacy Act of Nova Scotia, for example, where this is contained in Section 24. And it's hard to justify as necessary in all cases, that doing this is necessary in all cases, but it could vary with the circumstances. So you'd want to turn your mind to, is it a high trust position? And so the higher the degree of trust that's required, perhaps the higher degree of diligence that could be justified. Is it a high visibility position? So are people going to be regularly searching for that person's name? And you want to know what's going to come up, and it's going to reflect on their performance in that role, and it's also going to reflect on their employer. And again, consent is not a basis to collect personal information under most public sector laws. But frankly, because privacy is mainly about giving people choices about how their personal information is collected, used, and disclosed, and giving them some measure of control over it, something approximating consent makes the most sense. Letting the individual know that this will be done, and giving them an opportunity to object or to provide you with information about any of their misgivings. Now, behind both of these is the fact that collection of personal information has to be lawful. So under PIPEDA, it says that the collection has to be reasonable. Under Principle 3 of PIPEDA, the collection has to be lawful. And you need to think about, is the source of your information, is it lawful for you to be collecting information from that source for those purposes? Some social media sites prohibit the use of their services for background check purposes or for other things like that. And so you should be checking that to make sure, because it could be an invalid use of that service. And also, if it renders the collection unlawful in the first place, it could compromise the justification for doing it in the first place. And it could, if somebody were to complain about the integrity of the hiring process, might be a basis to attack the whole process for hiring. And absolutely, for God's sake, don't use deceit. So under no circumstances should anybody create a fake profile to friend candidates or to add them without being completely above board. And being above board would involve not having a fake profile. You could do it in your own name, but again, I don't think it's appropriate that one would go behind somebody's privacy protections to determine what information they share with just their friends. Now, in addition to human or privacy law considerations, there are some significant human rights considerations that I think are often missed in the context of this important discussion. When you take a look at somebody's social media profile, you will very likely find out information about them and their life that you would never be able to ask them in an interview because of human rights laws. You would never be able to, at least in Canada, ask somebody about their family status. But they might post about that on their Facebook page, for example. You would never be able to ask them about their religion, but you might see information about their religion on their Twitter feed. Likewise with disability, things like sexual orientation and gender expression. And once you've seen something, it can't be unseen. So you have taken it upon yourself to go out and collect information, perhaps behind the back of the candidate, and it's information that you would never be able to ask them directly. And it's information that can significantly tarnish the integrity of your hiring process. So somebody would be able to potentially attack the hiring process, attack their failure to be hired, on the basis that the decision-making was informed by prohibited grounds of discrimination under the relevant human rights law. And you don't want to do that. So for companies that do use social media background checks and that do exercise due diligence and best practices, which I'll talk about in a minute, one of the key things that I advise them to do is to have somebody else do that background check. Don't have the hiring manager, the decision maker, being the person who's looking at people's profiles, where they could be infected, for want of a better term, with information about those prohibited grounds of discrimination. So set up a screen, have somebody else do the social media background checking, have them provide them with a checklist saying these are the things we're looking for, and these are the only things that you can report back to the hiring manager about. Do not, under any circumstances, provide any information related to prohibited grounds of discrimination, for example. And that way, if you diligently follow that process, you can at least put in place a mechanism by which it's pretty clear that the hiring manager did not have that information at his or her disposal, and they were not in a position to use that information to make a derogatory hiring decision about that candidate. So what are some of the best practices that could or should be adopted across the board? And these are going to be applicable whether there's a privacy law or not. Now, there's always going to be human rights law that applies anywhere in Canada, federally, provincially, regardless. First thing, make sure you're getting the right person's information. That it's very easy to go into a search engine and put in somebody's name and come up with information about somebody else. Now, if somebody has a very common name, you're likely to get results that are largely useless because you have no idea whether you're looking at the information related to the right John McDonald, for example. But also, if it's an uncommon name, be very careful about a false sense of confidence that you might have. I remember being contacted a while ago by an individual, a recent university graduate, who had an uncommon name, who had sent out a whole bunch of resumes, did not get any nibbles, and then put his name into a search engine and found a case comment related to a charter case where it was a search warrant in a child sexual exploitation investigation. And the defendant in that and the accused in that case had the exact same name as this recent university graduate. And it's very likely that people were putting his name when he was applying for jobs into search engines, were finding information related to an individual accused of sexually abusing children, and his resume was going straight into the recycling or shredding bin. And that would have been a whole bunch of people making decisions with inaccurate or incomplete information. And if a privacy law is implicated, the accuracy principle of those privacy laws is also going to be implicated. You should consider whether or not the hiring manager should be involved in this, and best practices, at least in my mind, would say somebody else should be doing the checking just to make sure that the hiring manager does not become privy to information that the hiring manager should not be. I think it's always better to get consent in advance to avoid surprises so that everybody knows really what's going on, so that they're, at least one of the things that I've learned in my 20 years of practicing in this area, people feel their privacy has been invaded when something happens that doesn't meet their expectations with their personal information. So if a candidate knows that a social media background check is going to be carried out, they're not going to be surprised. And frankly, they get to take the opportunity to clean up any things that might be problematic behind them, which would be for their benefit in getting hired, but would also be for the benefit of the potential employer. I think that consent should be obtained at the time of the interview when you're shortening the list. Doing social media background checks on all of the candidates is a waste of time and resources and could be problematic. Once you've narrowed down the list of candidates who you want to interview, that would be the time to carry out the interview, advise them that a background check is going to be done, get their consent at that time, and then you can carry on. Absolutely, you should never ask for passwords to people's social media accounts. A number of years ago, a couple political parties tried to do that for prospective candidates and ended up in significant hot water, even though they're not subject to privacy laws. But again, things need to be very carefully done, very carefully documented, and you need to make sure that you're completely above boards and your hands are completely clean at all times. Remember the accuracy principle and also retain all the information that's used. Under many privacy laws, if information has been used to make a decision about somebody, that information needs to be retained for long enough so that the individual can challenge the accuracy or the completeness of that information or to get access to it. But first and foremost, perhaps consider whether a social media background check is reasonable or necessary in the circumstances. Do you need it? Is it reasonable for this particular role? And have a policy that articulates all of this. You're always going to be in a much better position if you have a policy in advance that has been clearly thought through, rather than making things up on the fly or having to justify things after the fact. If you have a policy that was subject of significant input from legal counsel, from HR professionals, and from others that you diligently follow, you're going to be your activities, your actions at the end of the day are going to be much more easy to justify compared to not having any policies, procedures, winging it along the way. You get a challenge to it after the fact, and it does seem like you're making up a justification afterwards. So hopefully this has been interesting, informative, and educational. As I always say, privacy is a very complicated area in Canada. It's one that changes regularly. There are also significant variations, not only from province to province, but also whether the workplace is unionized or not. And so if you're looking at this video because you have a particular situation, you should seek qualified legal counsel about your particular situation. Because this was intended to be a relatively high-level overview that talks about the principles involved, and sometimes when you get into the weeds, that there's exceptions to just about every rule. Anyways, I hope this has been interesting and informative and perhaps even educational. If you have any comments on this, please leave them down in the comments below, and if you have any suggestions for any future videos, I would love to hear them also in the comments below. Thanks for tuning in.